Thank you.
All right, thank you both. We'll call the next case Albert KODSI versus Fairview Grand. Morning, counsel.
Good morning, Your Honors. My name is David Glassman. I represent the appellants. I would like to reserve 3 minutes for rebuttal, please.
All right.
The trial court did not have case jurisdiction to adjudicate count 3 of the complaint against the guarantors because it did not reserve jurisdiction to do so in the amended final judgment of foreclosure. Case jurisdiction, as you'll recall, involves the power of a court over a particular case that is within its subject matter jurisdiction.
Why would the court need to reserve jurisdiction on the foreclosure to have jurisdiction to proceed on the guarantees? I mean, it seems to me that an action on a guarantee may have to come after the foreclosure in some cases, or they could come at the same time, or I suppose if the property's gone, could come beforehand. But it seems to me that they're unrelated. And I mean, there's certainly some relationship, but as a cause of action goes, as a remedy goes, they're unrelated. So if that, would you agree that the final judgment of foreclosure was separately appealable? They could have just gone and appealed it if they'd wanted to.
Yeah, I think the final judgment was a final judgment, and therefore it was appealable. I mean, remember, the final judgment of foreclosure was only against the defendants, against Lake Fairview Development, LLC, and against Blickfeld Anstalt, and against RPO Construction.
But the final judgment didn't address count 3 at all, and wouldn't really address count 3 at that stage. There was a stipulated judgment for foreclosure.
That's correct. That's the judgment that all of the...
Which doesn't address count 3.
That's correct.
And you're suggesting that the trial judge somehow loses jurisdiction over count 3 by entering a judgment on other counts.
That's the law, Your Honor, that if a final judgment appears to have the characteristics of a final judgment, and this judgment did. I mean, this wasn't some sort of interlocutory order or preliminary ruling that didn't provide for execution. This was a final judgment that was going to provide for, and did provide for, the sale of the property subject to the mortgages. And, you know, if you look at the Florida Supreme Court case in McGurn versus Scott, what the court says is, if a trial court improperly renders such a judgment which appears to be or has the attributes of a final judgment, the order will be deemed to have become final. And that's important because if it's a final judgment, what has to happen is the court has to reserve jurisdiction to adjudicate additional matters, and that's set forth in a number of different cases. In the foreclosure case, it's the 2 Ross cases that we've cited that make it clear that a trial court, if it wants to take additional action after the entry of a final judgment, the court is required to reserve jurisdiction to do so. And so...
Let me ask you this. The final judgment on count 1 was done by a stipulation.
Correct.
Not by a trial or some sort of hearing, but by a stipulation. Was there anything in the stipulation which indicated that any of the parties understood that this was final judgment for the entire case, or that was simply those? And there was actually 3 other counts.
That's correct, Your Honor. And so what you had is, this was a stipulation that was entered into by not all of the defendants, but a number of the defendants, the borrower, the 2 guarantors, and if I recall correctly, one of the junior lienors. And this was the judgment that these parties agreed to have entered in this case. You know, there was no...
I guess my question is, did they agree that that would be the only judgment in the case?
I think if you look at the stipulation, I think the conclusion that has to be drawn is yes, that because there was no provision for the reservation of jurisdiction. I mean, what typically happens in these cases is that the court will adjudicate the liability of the borrower, will adjudicate the liability of the guarantors, will provide for foreclosure, and then will reserve jurisdiction for deficiency judgments and only provide for execution for foreclosure. And if that had happened, we would be in a very different situation than we are in now.
Oh, but as a matter of practicality, you don't know what the guarantors are going to be on the hook for until after the collateral is sold. They might not be on the hook for anything if the property yields enough.
Right, so what happens is you have an adjudication as to the amount of the indebtedness, just like you would against the borrower. And again, it's the same thing. It would be an adjudication for the entire amount owed under the loan documents, but it would not provide for execution in the sense that the sheriff can come out and seize property or that bank accounts can be levied. Instead, what it would provide for would be the foreclosure of the collateral and then a reservation of jurisdiction to enter a deficiency judgment if, as you've noted, the collateral were insufficient to satisfy the amount of the indebtedness.
But you keep saying deficiency judgment, and the court talks about deficiency. The motion here was for a deficiency, but isn't there a difference between a deficiency action and an action on a guarantee?
Absolutely. That's the point of this. One of the things that the appellee does throughout the answer brief is to continue to say that the deficiency judgment was retained, that a deficiency judgment is simply a continuation. We are not disputing that the court reserved jurisdiction to enter a deficiency judgment. However, what the court had to do, and what the court recognized, and all the parties recognized, by the way, is that there had to be an adjudication on count 3 for breach of the guarantees before a deficiency judgment would be appropriate. And that's where that wasn't done. There was no attempt to reserve jurisdiction to adjudicate count 3, even though the court and the parties recognized that count 3 needed to be adjudicated. I mean, remember what happened here. Originally, they filed a motion for deficiency judgment against all of the defendants, and the guarantors moved to dismiss on the grounds that there was no judgment as to count 3, and the appellee, Fairview Grand of Orlando, voluntarily dropped the guarantors as defendants on that motion for deficiency with the recognition that they had not obtained a judgment as to count 3, and also, and the court agreed at some point during the proceedings, parallel with the deficiency judgment proceedings, the Fairview Grand of Orlando moved for a summary judgment as to count 3 of the complaint, and the court, despite our objections and that the court hadn't reserved jurisdiction, the court entered a summary judgment as to liability only and not as to damages, which brings up the issue that even if the court were to conclude that there was jurisdiction, and I don't think that there was jurisdiction. I mean, what I would say is that it's pretty clear that, and the case law is clear, and there's no exception that a court, if it wants to take action after the entry of a final judgment, all they have to do is simply reserve jurisdiction to do so, and that's all that had to happen in this case. Now, the minor carve-out to that is this Rob Corps case, and in the Rob Corps case, what they talk about is that even if a court doesn't reserve jurisdiction, the court can continue to adjudicate claims that are separate and are distinct and are factually based upon different facts. But that isn't what we have here.
Yeah, you don't suggest to this court that the parties ever intended to let the guarantors off the hook by entry of the judgment of foreclosure, do you?
What I would say to the court is that, the record that we have here is the record, and what we have here is a situation where all of these parties, this wasn't just a stipulation between.
I wondered if are you going to get to answering my question at some point?
Yeah, yes, I don't think the record, I think the only way to ascertain the party's intent is from the terms of the stipulation itself. There's no other record evidence as to what the party's intent was, and I think if you look at the stipulation.
Well, they could have agreed to dismiss count 3 as part of the stipulation.
Yeah, I mean, there's a lot of things that could have been agreed upon, and I'm hesitant to sort of speculate outside the record.
Well, but the bottom line is that the stipulation on the foreclosure addressed the action on the mortgage and the action on the note, and it didn't address in any way, other than perhaps your argument that by not addressing it, it meant perhaps to be abandoned. But the stipulation of foreclosure didn't address count 3 on the guarantee one way or the other, did it?
That's correct.
And you recognize, I think you have, that an action on a guarantee is separate. It's a separate remedy that can be pursued later, simultaneously. It's a completely separate remedy because it's an action on a contract, correct?
Yeah, let me sort of, I agree with you that I don't believe it's separate in the sense of Rob Corps, if that's what you're asking. I mean, what Rob Corps talks about is this is a case where a plaintiff, Rob Corps, sued Mr. Innes for conversion of shoes, believe it or not, and Mr. Innes counterclaimed for breach of contract with respect to the production of a video, and then for misrepresentation with respect to totally separate videos. And what the court said is that the court entered a judgment as to, on the complaint, and the court entered a judgment on count 1 of the counterclaim, but the court also said we can adjudicate count 2 because they're factually distinct. But understand the guarantee complaint and the foreclosure complaint share 20 different paragraphs. All of the things that need to be proven for the, and I think this is why they do this, by the way, but all the things that need to be proven in the foreclosure are matters that would need to be proven in the breach of guarantee. I mean, the only thing the breach of guarantee, the only additional fact would be the execution of the guarantees, but everything else, the execution of the mortgage, the amount lent under the loan documents, the default, the notice of default.
You've argued to us that they have a right on the guarantee to a jury trial, and certainly they didn't have a right to a jury trial in the foreclosure action, correct?
That's right, yes, yes.
Let me just, on this sort of commercial foreclosure case, it seems like the foreclosure was relatively clear. I mean, they hadn't paid the mortgage. Wasn't really the heart of the case against the guarantors? And if there was some intent to abandon that count, that should have been mentioned somewhere in the stipulation.
Well, again, I mean, I think if you view this as a final judgment that disposed of the case, I would say that if you wanted to I mean, remember, a final judgment is a final judgment, and typically a final judgment ends judicial labor. I would think the opposite would be true, that if you had intended to preserve it, and that's what happened in all these other cases. I mean, if you look at the cases cited, for example, the Weston case, the final judgment reserves jurisdiction for the guarantee. The Gordon case reserved jurisdiction. A lot of these cases, most of these cases cited by Fairview Grand of Orlando, there is a reservation of jurisdiction. Now, even if the court ultimately concludes that there was jurisdiction, what's clear is that, and remember, at that point what we're saying is the final judgment foreclosure did not in any manner affect, it wasn't against the guarantors. The Fairview Grand of Orlando still failed to prove the amount of the indebtedness owed by the guarantors. And
I thought there was a stipulation.
There was no stipulation as to the amount of the indebtedness. That's not correct.
Well, there was a stipulation as to the fair market value of the property, and
but what there wasn't, Your Honor,
was the amount of the loan in dispute?
Yes. What happened?
I know that they gave you a credit on some interest. So, I mean, other than potential legal defenses, lack of consideration, fraud, or something like that, what was there to fight about?
Well, in the complaint, the plaintiff alleged that a certain amount was owed, and all of the parties, including the guarantors, answered that allegation without knowledge. So that would be deemed a denial under the pleading. Therefore, the question was, what evidence established the amount of the indebtedness, not as to Lake Fairview Development, where the indebtedness as to Lake Fairview Development was clearly established, but as to Fairview Grand of Orlando, as to the guarantors, what evidence established the amount of the indebtedness? And they're simply...
Well, but your clients guaranteed a specific debt.
Yes.
The amount of that debt had been adjudicated.
Correct, Your Honor, as to Lake Fairview Development LLC.
Right, but your clients, assuming that there's no legal defense like fraud or lack of consideration, your client's guarantee was unconditional and unlimited. In other words, it was coextensive with the obligation of the original maker of that note.
Yes, that's right.
So what was there to talk about?
Because it's the Kahn versus Simpkins case, Your Honor, which is cited in the brief. The extent of the liability is determined by the contract of guarantee. But what's clear, and this is the important thing, this isn't a question.
Wasn't the contract of guarantee that says that if Judge Hodges doesn't pay, I'll pay, and so if he doesn't pay, I'm on the hook for what he owed?
Exactly, but if you get sued on that indebtedness and a judgment is entered against you, and then that creditor comes back against Judge Hodges and says, I'm going to sue you on your guarantee, Judge Hodges has the right at that point to say, I want proof that this is the amount of the indebtedness. And that's the Kahn versus Simpkins case. What it basically says is that a judgment against you, and that's all we have, remember the foreclosure judgment, everybody agrees is only against Lake Fairview Development, is not collateral estoppel. This isn't a question of the law of guarantee, Your Honor. What this is a question of the law of collateral estoppel, and that is whether this judgment against Lake Fairview Development in our case or against you in your hypothetical has collateral estoppel that prevents the guarantors in this case or Judge Hodges in the hypothetical from having their day in court to put the lender to its proof and establish the amount of the indebtedness. And that did not happen, Your Honor.
You're down to your rebuttal time.
In this case,
if you'd like to hold
I appreciate it, Your Honor. I will yield the podium.
Thank you.
Thank you.
Hold on just a minute. If you'll just agree with everything he said, we can get out of here.
I'm not that much in a rush, Your Honor.
Okay.
May it please the court, my name is Jack Pelzer here today representing the appellee Fairview Grand. And the fundamental questions before the court today is whether the foreclosure judgments, which addressed only one count on the complaint, should be interpreted so broadly that by implication they relieve the guarantors of $15 million worth of debt. Judge Munyon here did not misinterpret her own final judgments, nor did she misinterpret the stipulations of the parties that led up to those final judgments, and she correctly held, looking at the substance of the judgments, without looking for particular magic words, that she had case jurisdiction to decide this case, and she decided it correctly. We have to start with the observation that foreclosures are a little bit different from any other suit for money damages. The Collins case and the Park Financial case we cited note this, that even in a simple foreclosure, you may have a string of partial final judgments that lead up to the conclusion of all judicial labor in the case. And that's exactly what we had here. The foreclosure judgments were final judgments, as my colleague here says, but they're a specific kind. They were partial final judgments. They only related to count one. And did not go on to address anything having to do with the guarantees and did not adjudicate the guarantees. And there's 5 specific limitations in the judgments that do this. I'll rattle them off and then we can go back and discuss them. But the title of the foreclosure judgments themselves were a limitation. The language in the execution clause of the final foreclosure judgments was a limitation. The foreclosure judgment specifically reserved jurisdiction to adjudicate deficiency without limiting it to deficiency against the borrower, but would include deficiency against the guarantors. The foreclosure judgments failed to address the guarantees at all. They, did not reach the issues, which is consistent with the the stipulations, which did not reach those issues either. And most importantly, there was no language of finality whatsoever with respect to the guarantees or the guarantors. Now, to go back to it, the final judgments of foreclosure specifically were titled final judgments of foreclosure. They were limited to that count one, the foreclosure count on the note and mortgage, and the sole purpose was to get the property sold so that then we can move on to the next step in this foreclosure case, the next partial final judgment, which may be the conclusion, which is adjudicating the deficiency and concluding judicial labor.
Was the judgment prepared by Fairview?
It was prepared jointly, Your Honor. The parties jointly agreed to it. It was an attachment, an exhibit to a stipulation that all the parties jointly agreed. And by the way, the guarantors joined in that stipulation. They weren't strangers here. They weren't brought in later. They were joined in that stipulation for that final judgment.
I guess I'll ask the same type question. Since it was done by stipulation, why was it not made more clear that you still have the other three counts, including the guarantor count, still need to be adjudicated? We could resolve this whole thing by, a handful of words.
I'll concede this, Your Honor. It would have been better practice to include that language.
Okay.
What I will not concede is that it's an essential to include that language. And I think that this gets into the fact that the final judgments failed to address the guarantee count at all. And if you look at the Second District's recent decision in its Gulf Eagle case, they recited the entire procedural history of that foreclosure, and twice they noted that the partial final judgment of foreclosure simply failed to mention the guarantee counts. And that court had no qualms, no reservations whatsoever with going on to adjudicate the guarantee counts in a later final judgment in the same case.
Is a deficiency action and a action on the guarantee one and the same?
The answer is no. The word deficiency is sometimes used loosely to refer to both because we're giving the guarantors a benefit.
Not only sometimes, but I don't know about your motion, but your firm or your client's motion is a motion for a deficiency. And in fact, it wasn't for a deficiency at all. It was an action on a guarantee.
Well, in fact, we were seeking against both. We sought a deficiency against the borrowers and also the judgment for the same amount against the guarantors. The term deficiency was used because we're giving the guarantors the credit, obviously, for the value of the security that my client eventually purchased at the foreclosure sale. We could very well, and when I say we here, I mean the bank, my client's predecessor, could very well have simply sued on the guarantees and not foreclosed the property at all. And then the guarantors would have been deprived of the credit of the $10 million or so worth of fair market value of the property. We could have done that, simply done a straight action on the guarantee. And that's why I say, Your Honor, it's correct that the guarantee and the deficiency may be technically different things, but throughout this litigation, in fact, even in the briefing in here today, the word deficiency has been used to describe a judgment for the deficiency amount against the guarantors. And that's exactly what we had here. That was the reservation that the trial judge made pursuant to the parties' stipulation in the final judgment of foreclosure. And it was understood then, should be understood now. Judge Munyon certainly understood it. It was meant to be a reservation on everything except for the actual foreclosure of the property, which, as I say, is a standard operating procedure, even in a simple foreclosure, never mind a multi-million-dollar commercial foreclosure, that first you sell the property, then you move on to worry about deficiencies.
How do you respond to his argument that the amount of the underlying claim wasn't properly adjudicated? Their argument is that they're not bound by the amount of the foreclosure judgment, but as you observed, they joined in the stipulation.
That's absolutely right, Your Honor. I think my colleague is forgetting that on pages 5287 and 5289 of the record, the parties agreed as to the amount due on the note. Then they went on page 9170 of the record to stipulate to the guarantee. They stipulated the fair market value of the property and to credits for the settling the affirmative defenses on page 9171 of the record. And then on the next page, 9172, they stipulated that no further payments had been made or received on the mortgage or the note. After that's done, there's nothing left. There's no adjudication to be had, whether it be by judge or by jury. Everything has been stipulated to. From here, it's just a matter of taking pen to paper or calculator to paper and printing out the amount. It was all stipulated to, and those stipulations included the guarantors at every stage. There was in the brief the suggestion, it wasn't addressed here at oral argument, but I'll bring it up here since we have a little bit of time, that the dicta from the Jonas case should be used to create a whole new affirmative defense in the state of Florida. That argument has been rejected by the court that issued the dicta as well as by the 4th District, and we suggest that this court should not take this opportunity to create conflict with those two districts, especially since the affirmative defense that they seek to create is one that would disrupt the entire secondary mortgage market and should not be done. We also talked about
But it would change the secondary mortgage market for sure. I don't know, I guess there would still be some market, but it would be greatly changed.
well, you would no longer have any kind of incentive for people in the secondary market to pay larger payments to the seller of the mortgage. And as I said before, there were really no facts to try in this case, whether it was in front of a judge or in front of a jury. So the whole issue of a jury trial is frankly a moot point. Unless there's any further questions on the remaining points, we'll rest on the briefs. We ask you to affirm. Thank you.
Your Honors, the reason the Fairview Grand of Orlando LLC can't win this case are twofold. Either the court did not properly retain jurisdiction, and remember, to retain jurisdiction, there has to be an express reservation of jurisdiction, except if the cases are separate and distinct, and these cases aren't separate and distinct. And I would add that the failure to reserve jurisdiction, I would cite the court to the Amex Civil LLC versus State Department of Transportation case. A final judgment not only concludes every issue adjudicated, but every justiciable issue in the case. And
Didn't that deal with a construction bond?
it did, Your Honor. I mean,
Wasn't that a factually distinct case because?
Of course, it was factually distinct, but I think the legal principle certainly is equally applicable. I don't know that, collateral estoppel and res judicata issues are different in foreclosure than they are in construction cases.
What about the fact that your clients, to the extent that you wanted to litigate the amount of the debt, what effect does it have that your clients joined in the stipulation as to the amount of the debt? Well,
I don't think they did, and there are two stipulations here, and I'm not entirely sure which one. Opposing counsel referred to the stipulation, the joint stipulation of facts. There's two stipulations. There's the stipulation that was for the entry of a judgment against Lake Fairview Development LLC. There was no stipulation as to the amount of the indebtedness there. If you look at the stipulation, all it says is, we agree to the entry of this judgment against this party.
But didn't the judgment that was attached to that have all the numbers in it?
It did, but it was also a stipulation as to the entry of judgment against a single party. It was not a stipulation for a judgment. It wasn't an agreement.
Did your clients sign that?
My clients, I don't recall if the client signed it or whether it was done through counsel, but yes, the parties stipulated for the entry of a judgment against Lake Fairview Development LLC. And we're not seeking any relief from that stipulation. We're asking that that stipulation simply be enforced in accordance with its terms.
Much of this case has been stipulated to throughout the case.
Yeah,
But yet here we are in appeal. Is there anything to the suggestion by the appellee that this is kind of a gotcha situation?
Not at all.
We stipulated it, by the way, we left off a word, and now we win.
Not at all. I mean, we would, again, I'll confine my statements to the record, obviously. I'm not going to go outside of the record, but we would say that the opposite. I mean, we are simply asking that the stipulation and the judgments entered pursuant to the stipulation be enforced in accordance with the law. And the law is clear that a court has to retain jurisdiction if it wants to adjudicate matters that haven't been adjudicated. And that's all we're asking. So no gotcha here.
All right, counsel, you've exhausted your time. Thank you both
Thank you, Your
for
Honors.
your argument.
Thank you very much.
We'll take a short recess and invite